So let's go ahead and start it here. I'm going to bring on the next two speakers that are just world class. I don't even know where to start. Asset protection is their area of expertise. High net worth individuals they work with. They were elected best lawyers list 20 billions and billions of dollars of clients' assets that they know how to protect. These two gentlemen know each other and work with each other, and we're going to have a really great presentation from them combined. They speak, and there's no question you can ask these two attorneys with regard to asset protection that they can't answer. So I'd like to welcome Brian Bradley and Douglas Lodmell to the event. Guys, welcome and take it away.
Thanks, Moose, for having us, and thanks, Mike, for getting all of this set up, and really looking forward to blowing up a lot of misconceptions.
Yeah, great to
Great.
be here. Really happy to have the conversation and learn a lot about how you protect all this real estate from lawsuits.
Hi guys, just a
Very good, guys.
quick
The
interruption.
floor's yours.
Just a quick business, real quickly. We're going to go ahead and open up the other room. So it's the panelist room. And we're going to go ahead and send over Mike Morawski, Dugan Kelly, Chad DeFore, and other panelists. So please just be aware of that. If you need me to move you over, please message me in the chat box, and I'll be more than happy to do so. Thank you.
Okay, guys, take it away.
All right, and so like we were saying, thank you everyone for joining us today and virtually, especially, the craziness on. I'm glad we were able to get this summit going. And I don't take it lightly that you gave up 3 days of your life for this event. Your time is valuable and it's to never get back. And if somebody wants my time, then they better deliver, because my time is valuable. And so I guarantee you that we're going to deliver for you, and the other great speakers during the summit, they're going to deliver also. I know a lot of them personally. And so just a little bit about myself, I'm Brian T. Bradley, and with me is Douglas Lodmell. We're both licensed attorneys and focus exclusively on asset protection for investors. I'm the senior managing partner of Bradley Legal Corp. And just a little bit more about myself and why I'm talking. I've been selected to America's Best Attorneys list, top 100 high-stake litigators list, Super Lawyers Rising Star list, Lawyer of Distinction list, just a lot of other lists. And I hope that the key concepts that will help all of you watching and listening to better plan and take the preventative steps to protect yourselves. And so before we dive deep into this topic, I'm going to have Doug introduce himself, and then I'm going to jump back in and start us off.
So my name is Douglas Lodmell, and I'm the managing partner of Lodmell. And I've done nothing but asset protection for the past 23 years. And this involves domestic, offshore, and all of the in-between. I work with over 4,000 clients and protect about $5 billion worth of client assets. So that's all I do. Brian and I work extensively together. And, in the last 2-3 years, this concept of real estate investing has taken off. People have figured out that this is a very, very high-powered way to take your money and leverage it and invest it. And done right, it's risk a great deal. So a summit like this is educating you on a very powerful investment strategy. It's very important, though, that you also take the steps as you're building to get your assets in the right spot. If you don't, what happens, and we see this a lot, Brian and I will get calls from people, and they've been doing this now for 5 or 10 years, but they didn't get the plan set up in the front end, and now they've got a big mess. And cleaning it up after this is very difficult. And that's if you don't get sued. If you do, it's pretty much impossible. So what we're going to teach you today is really how to get it right. And please ask your questions. I don't know how that is done, if there's a chat or so forth. Also, are we sharing the screen? Can I share my PowerPoint? Is that going to work?
Yes, of course.
Yeah.
So you have co-host capabilities, Brian and Douglas. You can go ahead and share your screen however you wish.
Okay.
And it should be good to go.
Yeah, and I see the chat. I found the chat box. So as we switch back and forth, I'll just keep track of some of the questions popping up.
Okay. All right. So so everybody see the screen all right?
All right. I think the universal virtual thing is what, 777s? Isn't that what I heard from some other virtual ones? Like, yes, agreement. So
Yes, yes, yes. Okay, good.
all right.
All right, so there's us, and Brian, you want to start it off, or?
Yeah, I'll start us off, and then we'll kick this off with some great knowledge now. And so we're going to be talking about asset protection, and like I said in the beginning, like we're going to be bursting just a lot of misconceptions today and just blowing up the status quo about asset protection and LLCs and trust. And that's just going to be the big value you're going to be getting. You're going to be learning a lot about how to invest and different principles from here, but like at the end of the day, we want to protect what you're investing in and what you're creating. And so you're just going to be getting a very deep understanding of asset protection, how to layer it, and how to scale your planning as you grow. Now, I've talked on a lot of investment shows, and I've talked on, most of the other presenter shows that you're going to be learning from throughout the summit. And the constant takeaway really is that as investors, you're so focused on growing and adding to your portfolio and raising capital, closing deals, return on investments, analyzing metrics, but you don't think about what needs to get done to properly protect those assets. You don't look at the liability and legal risk and how you can lose it generally until it's too late or until you're already being sued. Most don't even understand how they can lose their investments or where their liability and risk even are with their businesses, their personal lives, and on top of it, the assets. And so they're generally taking a blind hook shot to the face, and most of their assets are generally held in the I don't know what I don't know side of the pie chart. And that's a very dangerous place to be. And that's what this talk about, is about today, the different layers and the tools and strategies that exist to protect what you've built and are in the process of building and the legacy you want to leave for your kids and your grandkids. And so let's just start with the very basics, just like the sound of music, do, re, mi, we have the note C, D, E. I'm teaching my 4-year-old daughter right now how to play the piano. And so there's thousands of songs you can play just by learning 3 basic notes, C, D, E. And so we're also going to want to start at the very beginning, just like the sound of music. So let's start with the concept of what is asset protection and what are the key goals? What asset protection is simply, it's creating legal barriers between you and your assets. It's really that simple. It's just like a safe. You want to put your valuables like your guns, your jewelry, your watches, your gold tucked away safely in that safe. I'm a big believer in the idea that success leaves clues. And if you want to be rich, you mimic the rich. So just like the rich, we want you to have the benefit, the use, and the enjoyment of what you own while separating out the liability side of it. Rich people don't own things personally. They just use them, they enjoy them, they get the benefit from them. And so you want to be able to go out and, use your boat or your plane or your car, enjoy it, rent out your properties, build your real estate portfolio, but you just don't want to own it personally. Instead, your asset protection trust and your business entities need to own it. And the role of asset protection is simple. It really is just peace of mind and lifestyle preservation. So when a client calls us asking for asset protection, that's what they're really saying. You want less stress knowing your finances and your assets are actually safe. Nobody wants fear paralyzing them. You want to keep what you have and what you worked so hard over the years to build. Asset protection planning is the modern best bet to level that playing field against this out of control legal system, and we do this just by using the different tools we have, but properly, like LLCs, LPs, and asset protection trust. And what this does is it makes it very hard for creditors to collect on you. Now you might be asking me like, hey, Brian, what's up? What happened with the legal system? Like, what's changed? And a heck of a lot's changed over the past 40 years. It's no longer about justice, but it's really about redistributing your wealth from the haves, which is you, the people owning the real estate, to the have-nots. And now for people who grew up, with a more old school mindset where lawsuits were never really an issue, back about 40 years ago, you could essentially have everything in your own personal name or in a family trust. That was acceptable then, and you can get away with that about 30 or more years ago. But over the past 40 years, the litigation landscape's just completely changed. Things that just didn't happen in the past or weren't even allowed to happen in the past, like contingency fee lawyers or law firm advertising, are just commonplace now. And this created law firms that are just purely sales and profit driven. They're representing clients who have no skin in the game. They have nothing to lose. And in the US, we don't even have a if you lose, you pay system like other countries. And so we have plaintiffs simply looking for targets to get a big payday out of in a legal system that's no longer about justice, and they're not looking out for you. And so asset protection is your modern best bet to level that playing field against these modern wealth destroyers. We're no longer really talking about death taxes that are destroying your family wealth, but predatory lawsuits, divorce, out of control medical costs. These are your modern day wealth destroyers. And so by using all the different tools that we have and that we're going to break down, what this does is it makes it very hard for creditors to collect on you. And when your planning is done properly and when it's seen as being very effective and impenetrable, this then puts you in a lot stronger position at the negotiating table. In fact, it chases most people away. And so we have a saying, you want to make yourself look as ugly as possible to a potential creditor. Like, I can't stop you from being sued. Doug can't stop you from being sued. Nobody can. That just comes as a byproduct of success and increasing your visibility as your holdings increase. But we can help you with how collectible you are. And this then puts you in a position of strength and gives you more legal leverage. And so the result is that you're going to radically deter the majority of these predators. And if you do get attacked or sued, you now have the proper tools and the systems in place beforehand, and by being proactive to successfully protect your assets. And so you're going to end up being happier, less stressed, more productive, since you're going to have less fear about conducting your business, hiring and firing workers, contracting, investing, adding to your portfolio, syndicating deals, even heck, sending your kids off to drive your car. You're just going to have more peace of mind about your financial security. Now, for all this to work, 4 things have to be true. Your system must be seen as impenetrable. It must be managed properly. The plan cannot attract a lawyer wanting to challenge it, thinking they're going to get a payday, and it must work. And so as a client, we then know that you want 4 things. You want an effective plan. You want to control your plan. You want reasonable and sustainable cost. And you want a plan that's easy to maintain compliance on. And so here's where we're going to go and break down the tools we use to accomplish all this. We have the LLC, Limited Liability Company, the AMLP, which is an Asset Management Limited Partnership, and the Asset Protection Trust, or like a bridge trust for Quantum Living Trust. And so let's just start breaking these tools down. When it comes to asset protection, we have different layers. I'm from the mountains in Lake Tahoe. We get lots of snow. I also lived in Michigan. It's freezing cold in Michigan. We also learn how to dress in layers. The first layer is your base layer. It's generally made from merino wool and it sits on your skin. And then you're going to want some sort of mid layer, which is usually a little thicker, and it can be synthetic, or wool. This keeps you nice and dry. And then you want an outer shell layer, which is going to be your waterproof layer. And this is going to keep you nice and warm, dry when the weather gets really bad and it's cold out there, it's rainy. But by layering, you're now more flexible. When it gets hot, and you're skiing or ice fishing, you can take the outer layer off or the inner layer off or the middle layer off. You can adjust and make yourself more comfortable. And the same principle applies with your asset protection planning. The base layer is your LLC, the limited liability company. It's going to be holding your real estate. So let's just start with the LLC. The LLC is a great, like I said, first layer, and it's the entry place to start. It's the foundation. They're great asset holding companies. We place things in them that have keys and that can go boom, or things that can hurt people, things that you need to get insurance for, like rental properties. You can place all your risky assets into an LLC, but you want to separate asset holdings from operations and operate your business dealings out of another LLC called an operating company. So if you're considering just this first entry level protection, maybe you're just starting out, you should consider at least at minimal setting up 2 LLCs. But by using LLCs, what you're doing now is limiting some of your personal liability and separating ownership, use, and control. And if you're trying to protect just a few assets and money's limited, the LLC is a great place to start. But everything has kryptonite, like just talk to Superman, kryptonite's not good. The LLC lacks on efficiency. Just remember that there may be protection, and it says it straight up in the name, first letter, first word, limited. They don't hide that fact. And there's lots of case law that exists around this. And we've all heard this term, piercing the corporate veil. And now the problem generally is that most clients come to me and Doug with, 15 LLCs, and they're all single member LLCs, and they're all disregarded entities and all in the client's personal name as the member. So now we have a problem here from an asset protection standpoint, because the courts have a tendency to disregard those single member LLCs held in an individual, your personal name, for example, in a state like California. And just as a full disclosure here, like I'm going to pick on California a lot in this seminar, and it's just because they want to take so much from you. And so a single member LLC held in your personal name is basically worthless. It really comes down to how you use them all together. And the next big misconception people have with LLCs is where to even set these LLCs up in. Do you go to Delaware, Wyoming, Texas, Nevada? You know, you hear about these states, and some of these states have privacy. And so people say, oh, hey, it's better to go do that, so I'm going to go and do that. Well, it really comes down to an issue of just what are you holding? You know, so let's say, for example, it's California real estate, and you set up a Wyoming LLC or a Delaware LLC because somebody on the internet or your CPA told you it was better. And then you bring it to California by holding a key piece of California real estate in it. And you're also paying California franchise tax now. What you've done is just convert your Wyoming LLC or Delaware LLC to a California LLC because you're doing business in the state of California. Not only are you going to pay the franchise tax there, but if you ever did have a liability issue in California, like you're being sued there, a judge in California or any other state that that asset's in isn't going to, care what state you created your LLC in. What law are they going to apply? The law of California or wherever that asset's at, right? Not Wyoming or Delaware. A judge in California or any other state doesn't care that your LLC is in Wyoming or Delaware or Texas. What they care about is, where are you doing business at? Where's the asset at? Where's the injury at? Where's the damage at? Those tort laws, those damage laws, those injury laws of that state, where the jurisdiction is, or what's going to be applied. And so we just need to clear up that misconception of when it comes to real estate, you want to own have an LLC set up in the state where the real estate is at. And then we have another big misconception when it comes to series LLCs. It's become the really hot topic and flavor that we've been hearing, a lot of people talking about. They're just very young, and there's no case law to rely on. And only a few states actually have series LLC statutes. What this means is that if you live in a state that does not accept series LLCs and doesn't have series LLC legislation like California, you won't get the benefit of them. And they're still only as strong as a traditional LLC. Now, I like series LLCs, but only for individuals who live in the state that has series LLC statutes, and the asset itself that you own is also in a series LLC state. If you don't meet those criteria, I would never recommend someone going to use a series LLC. Otherwise, it's just going to be disregarded and just treated like a traditional LLC, and it's basically worthless. And then we have a really big misconception of LLCs, and that's anonymity. And the thought here is that you can just create an anonymous Wyoming LLC and you can just disappear and can never be found. That the LLC member's name is not available to the public, and you can completely avoid a lawsuit. And this is just completely false. They have their place in the asset protection world as a first line of defense for business owners for privacy reasons, and not placing yourself at risk of harm or harassment. But this doesn't mean that your identity can't be found, or that, when your LLC is sued, that you won't be legally required to appear and defend your LLC. Then the complaint will simply be amended at that point, and you're going to be named personally anyways. The simple reality is that once a lawsuit is filed, the discovery process of litigation begins, and you'll be served. And then you're going to be subpoenaed and forced into court. And what's even worse is that if you want secrecy to even work, also known as lying under oath, that's a one-way ticket to jail. An example of this is that very shortly after judgment is entered against you, the creditor has a legal right to demand information about the assets owned by you, and courts enforce these rights very broadly. And so at this point in litigation, the only way to have anonymity or secrecy is to lie about them and commit perjury. And so we don't advocate for hiding. We just prefer to have a full disclosure of a proper asset protection plan and just set it up properly from the beginning to work. So for assets that are real estate, again, we recommend using the state that the real estate is located in, because you're not gaining anything by using another state. You're just doubling your maintenance cost. So just keep it simple and then add layers to the protection system as you grow. Just remember, the weakness with LLCs is that it's still just maybe protection and used more as a deterrent. Maybe it's going to be upheld and maybe not. Maybe the judge will pierce the corporate veil, maybe not. There's just a lot of uncertainty, and that's not good, especially when strength and power is important. The second tool or layer is the AMLP, the Asset Management Limited Partnership. It's simple, it's similar to an LLC in that it has a layer of protection around it to limit your liability, and they have some charging order protection. This mid layer is your holding company, and it's the mid layer where you actually do want to use one of these states that has really good protection around the LLC, like Arizona, Nevada, Wyoming, or Delaware. This mid layer protection, the second layer, should be a multi-member entity. Whereas that foundational layer, the base layer, the LLC that we just talked about, it can be a single member LLC, because at that base layer level, that single member LLC gets disregarded for tax purposes, but they also unfortunately get disregarded for asset protection purposes. But as you stage and grow your protection, you want it disregarded for tax purposes, because when a client comes to me with 15 pieces of real estate and with 15 LLCs, we don't want that client to have 15 separate tax returns. So by making those base layer LLCs single member LLCs, it helps with tax filings when you add the mid layer asset management limited partnership, because all those K1s flow directly through to the management company. But the AMLP is a step up from an LLC, since it also works very well as an asset holding company, because it has two different classes of ownership that an LLC just doesn't have. They have a general partnership interest and a limited partnership interest. The general partner is the controlling interest, and that's typically you, the client, which gives you control of your assets and to keep investing. And then the limited minority partnership is your asset protection bridge trust, and that's the ownership interest. By dividing it up like this, you get a separation of ownership and control. And remember, asset protection is about separation, strength, and power. You just can't get this with an LLC. But unfortunately, I see a lot of clients having the second layer protection being another LLC or even an S Corp, and not a limited partnership. And that's just not good. We use an Arizona asset management limited partnership as the starting point for clients, as that mid layer holding company. And then we add a bridge trust to it for actual strong asset protection components. The main reason we use Arizona for the LP is because of ARS section 29-333. That specifically allows for a limited partnership to make what's called a unilateral withdrawal from the limited partnership upon the occurrence of a predefined event. And this is unique to Arizona specifically, and it becomes very handy for us when we connect the third layer, the asset protection trust, to the limited partnership, because it allows the trust to then disconnect from the holding company during a time of duress. And this can't be done with an LLC. But it really is the combination of the two working together, the AMLP and the trust, that you want to capitalize on. And then the third tool, the third layer, is the outer shell bad weather layer. It's the dead of winter. You're in the frozen tundra or hiking around in Siberia in winter. And it's the asset protection trust. It's the heart and soul of the system. And then this is where Doug's going to pick it up and take over and break this down.
Yeah, great job, Brian. I think everybody probably had a few misconceptions right there just burst regarding the use of LLCs and the privacy jurisdictions and all of those things. We're fans of LLCs, don't get us wrong. They have their place, but just like everything, if you go out with only a base layer on and it gets really cold, it's not going to do you the good that it is if it's not really cold. So we're at the asset protection trust level. This is the key to the entire structure. This is where we really put the teeth into it. And the reason is because this is where we can add a jurisdiction that is not US based. So the United States is a great place to make money. It's a great place to invest. It is the world's most litigious society. And 75 cents out of every dollar that goes through the legal system doesn't get to plaintiffs. It gets to attorneys and all of the support structure around it. And so if it really is bad weather, I mean extremely bad weather, we want to be able to actually exit the US. This is where the asset protection trust comes in. It massively enhances those domestic structures It's not limited to a specific type of risk. It's going to cover anything and everything. It can add and increase privacy. And again, as Brian said, we're not against privacy. Privacy or secrecy as an asset protection plan doesn't work. But if you want some privacy, there's absolutely, it's available to you and it's useful. And these trusts can be set up in 3 different ways, which is domestic, foreign, or bridged. So we're going to spend some time on this and really explain this. And after this, you're going to know more than 99% of attorneys out there about asset protection trusts. So what is an asset protection trust? An asset protection trust is what's called a self-settled spendthrift trust. So all self-settled means is that you are creating it for yourself. So you're not creating it for your kids or your grandkids. It's not Daddy Warbucks creating it for little orphan Annie. It's you creating it for yourself. You're probably familiar with another type of self-settled trust, which is called a revocable living trust. Many of you have these. Many of your family members have these. They're the same in that they are self-settled. They're created for you by you. The difference is with an asset protection version of this trust, it includes these critical provisions called spendthrift provisions. And what spendthrift provisions are is they are provisions that protect assets from creditors. They're the actual teeth behind it. And for those to work, the trust has to be not revocable, but irrevocable. So it's a very different type of trust. Now there's 2 major schools of thought, international and domestic. So let's talk about both, because it's very important if you're going to understand how the trusts work and why the bridge trust works the way it works, that you understand the 2 base components. The international trust came first. The first jurisdiction was the Cook Islands. They passed the Cook Islands Trust Act in 1984. So that's 36 years ago. So it's now got quite a bit of history, and we've got quite a bit of case law. This Cook Islands Trust starts with a statutory non-recognition of any other jurisdiction in the world, including the United States, court orders and judicial proceedings. That means that if you have a judgment against you in the United States and they take it down to the Cook Islands, it's worth 0. It literally has no value whatsoever. Statutorily, the Cook Islands is prohibited from recognizing it. If someone wants to sue your trust in the Cook Islands, they have to start their case over from scratch. They have to prove their case beyond a reasonable doubt. That's the murder standard. That is the 99% sure standard. That is incredibly difficult to meet. In the US, a civil case is just the 51% standard, just the preponderance of the evidence. Yeah, I think more likely than not, that's what happened. But the beyond a reasonable standard is incredibly difficult to meet, and it doesn't get met, especially not in the Cook Islands. You're not going to be able to get a contingent fee attorney because they're not allowed down there. It's unethical in the Cook Islands, just like it used to be unethical here in the United States. It used to be. That got changed in the 60s because lawyers realized, wow, if we can't get part of the action, it's harder to get lawsuits going. In the United States, it's common practice to file a lawsuit and then get into discovery, start digging up things, and then amend your claim and go, oh, well, we found a different thing. You know, we didn't even know about this, and we're going to change our mind about what we're suing about. That's not allowed in the Cook Islands. You cannot amend your claim. And as Brian said, in the United States, probably the single worst rule we have is that the loser does not get doesn't have to pay the legal fees and costs of the winner. So if you get sued by somebody for a completely bogus reason, I mean, really just a complete frivolous lawsuit, and you spend $200,000 in legal fees, and finally the court throws it out, you're out $200,000. That guy that sued you is not going to be given the bill, because our system, that would discourage lawsuits. And of course, our legal system run by trial attorneys do not want to discourage lawsuits. So therefore, we don't have that system. Well, in the Cook Islands, of course, they do have that system. So when you lose your lawsuit in the Cook Islands because you couldn't prove your case beyond a reasonable doubt, you're going to face full fees and costs of the winner for legal fees. So the disincentive is massive. Not to mention the statute of limitations is short. By the time anybody actually figures out that there's a Cook Islands trust involved, very likely they're barred from even filing the suit down there. So in practicing law and doing thousands of these trusts, I've had a sum total of 0 plaintiffs that have followed any of my clients down to the Cook Islands. It's just too daunting a task. It really is. It's not something that anyone has ever been successful doing, and you would have to pay. There's nobody's gonna do it on a contingent fee. You can't. So it's incredibly powerful. So if we look at the 4-part test that Brian laid out, this one on effectiveness, flying colors. I mean, by far the most effective type of asset protection trust in the world. There's nobody that I know of that argues that. And a fully offshore asset protection trust is the best that it comes. What about the drawbacks? Well, it's expensive. Setting up a foreign trust is not a small or inexpensive proposition. They usually run around $35,000 to $75,000 to establish a trust like that. I quote my clients $10,000 a year to maintain a trust like that. That includes filing Form 3520 and 3520 each year, which is a full balance sheet disclosure of all the trust assets, all of the terms of the trust that are relevant, including in some cases an entire copy of the trust with the IRS. That form is not cheap to fill out from a CPA standpoint, and it's not something that most of my clients are too excited about providing to the IRS. If the assets are moved offshore because you have an offshore trust, which is obviously recommended, if you're going to the level of putting an offshore trust in place, you probably need to put the assets offshore as well. Then you have additional compliance called FACTA, foreign account tax compliance. And of course, you're not going to be in control of that trust. It doesn't work if you're in control of it. You need to have the trust company down in the Cook Islands be in control of the trust assets. That's why it works so well. So many clients are just not quite comfortable with that. They're not familiar or comfortable with offshore banking. And so the drawbacks are back to our 4-part test. Control, no, you're not going to be in control of that trust. Cost, not super reasonable. It's pretty expensive. And compliance, there's actually a fair amount of compliance. So while we have the most effective trust in the world by far, it's not something that we usually are starting out with because of the fact that there are these drawbacks: the control, the cost, and the compliance. I have some cases here. I'm not going to go through each of them. I'm just going to briefly flash them on the screen. You're welcome to look these up. These are foreign asset protection trust cases. Basically, just look at the bottom. The result, assets were protected. U.S. versus Grant. This is an IRS case with a $36 million IRS debt. Assets were protected. So even the IRS was not able to break the trust. Solo case, SEC, super creditor case. Again, assets were protected. These are kind of the worst case scenarios that I could even find. And even in those bad cases, the Foreign Asset Protection Trust, in particular, the Cook Islands Trust, was able to protect the assets. So again, that goes to the effectiveness of the trust. So let's talk about the domestic side. These came along later. 1998, Alaska actually passed the first statute. And the theory was, why are we sending all this business down to the Cook Islands and the other 24 jurisdictions around the world that have passed foreign asset protection trust legislation? Why don't we do it here? I mean, we've been doing it for years in Nevada and Wyoming. Why not just create an asset protection trust statute in Alaska? And so they did. And it was a well-drafted statute. I know the drafter of the statute. He's was a professor of mine at NYU. And the statute is as good as could be. And not to be left out, Nevada and Wyoming and Delaware all jumped right on board and said, hey, great idea. Why should we send the business to Alaska? We're already the asset protection jurisdictions. Let's go here. And so now we have 19, well more than a third of the US states that have passed some form of domestic asset protection trust legislation, which is really a testament to how needed this is and how recognized the states have looked at asset protection and said, you know what, this is a valid thing for people to do. Our legal system is a valid threat, and setting up something to protect your assets is allowable, it's ethical, It is not against our public policy, definitely not in these 19 states, and not federally, by the way. We have lots of federal asset protection that you already have. You have ERISA plans that are already protected from lawsuits, and all sorts of other exempt assets. So asset protection as a concept, it's very important you understand, is valid. How you do it is really where it gets important. So the domestic trusts were kind of popular in the early 2000s because a lot of people said, wow, well, why go offshore? It's less expensive, it's easier. So what were the advantages? Well, cost. A lot of domestic attorneys here said, you know, I was never comfortable offshore, but I'm very comfortable doing a Nevada trust where I have a trust company who gave me boilerplate language and told me how to do it. And I went to a seminar and I learned. And so, you know, these trusts could be as little as $10,000 to set up. There wasn't the same compliance either because these are not foreign trusts. Much of that compliance that we were talking about is related to a foreign asset protection trust. So Form 3520 and 3520A, not required to be filed. FACTA, not required because we didn't have any foreign accounts. So that's great. These are advantages. What are the disadvantages? Well, unfortunately, effectiveness. We live in the United States of America. We have a constitution, and Article 4, Section 1 of the US Constitution actually says that the states must grant full faith and credit to the laws, judicial proceedings of other states. So while Alaska and Nevada and Delaware would like to say that they can protect assets from a California judgment, the reality is that unlike the Cook Islands, which can just throw that California judgment in the trash, Nevada cannot. They must respect it constitutionally, they must domesticate it, and they must litigate it. And so what's happened is we've now got case law, and it started coming around 2006, 2007, 2009. And what we find is that these trusts have failed. They have not been effective. So these are the challenges. You know, we've got full faith and credit, which I said, choice of law issues. You know, which law is the judge going to apply? Just like Brian said, you think you're doing yourself a favor using a Wyoming LLC to hold a piece of California real estate, and then all of a sudden you realize, oh, California law is going to apply anyway. Well, the same thing is happening in the trust world. Bankruptcy code has specifically addressed self-settled spendthrift trust. And then even in the DAPT states, the 19 states, there's lots of exceptions to what those trusts can protect. So the results are that the judges have found ways around them. So again, I'm not going to go in detail over these cases. You can definitely read them or look them up for yourself. But the bottom line is 2011, Mortensen tried to use an Alaska trust. Result, complete loss of assets, complete failure of the trust. Huber, again, Alaska, DAPT 2008, was a bankruptcy case. Result, complete failure of the trust, loss of the assets. Stillman, Kilker versus Stillman. This is a very interesting case because it actually stands for the proposition that's in California, at least, that's setting up an asset protection trust is in and of itself going to be evidence of a fraudulent transfer. So, you know, bottom line, complete trust failure, loss of the assets. So while there was a lot of excitement around the DAPTs in the early 2000s, I think there's not much excitement around them now. I don't know personally any attorneys that still use them, or they do. If they do, they use them very sparingly. They only use them for clients that live in the state where there's the statute. So just like Brian said, you would not want to use a series LLC unless you're in a state that has a series LLC statute. The same is true with the DAPT. You would not want to use one if you don't live in a state that has a statute. Maybe you would want to use one if you live in that state. And again, I say maybe because if there's a better solution, why would you not want to use that? And so this is where we get to the better solution. Another DAPT case that's interesting, Dahl versus Dahl. This is a divorce case between two asset protection jurisdictions, Utah and Nevada, which both have a statute. At the end of the day, the judge didn't care about either statute. Trust failed, complete loss of the assets. The trust was disregarded completely. So that's when we get to now the hybrid options. So much like hybrid cars, there's real advantages when taking some of the really good parts of each of these things. So there are two basic forms of hybrid. There's domestic hybrid trusts that are all purely domestic. I'm not going to talk a lot about those because, again, they're domestic. They don't give you any foreign capacity. At the end of the day, they're still just as subject to the judge's discretion or indiscretion, if you want to call it that. And so I'm not a big fan. The foreign domestic hybrid, though, I am a big fan. In fact, I'm pretty much the creator of the foreign domestic hybrid in what's called the Bridge Trust. And the Bridge Trust is the premier foreign domestic hybrid trust. And it is something that I've been using for over 20 years. So what is a bridge trust? A bridge trust is a foreign asset protection trust. So it's a foreign trust. It's actually drafted as a foreign asset protection trust. It's registered in an offshore jurisdiction. And then for the purposes of IRS compliance, it is bridged back into the United States. And it meets the two-part test, which allows it to be treated as a domestic trust for tax purposes. So it's just like having two passports. You can have a Swiss passport and you can have a US passport. And as long as you have a US passport, the US considers you a US resident and it doesn't care that you have a Swiss passport. The same thing is true with trusts. As long as you meet this two-part test under 7701, the US says this is a domestic trust. So the tests are the court test and the control test. So as long as there's a US jurisdiction that has primary supervision over the trust, we meet the court test. And as long as there is a US person with primary control over the trust, we meet the control test. So how do we do that? Well, we recite a US jurisdiction for the trust. In other words, we assign a US jurisdiction. Which one we're going to use depends on where you live. If you live in one of those 19 states that have a DAPT statute, we're going to use that state. If you live in another state that doesn't have a DAPT statute, we're going to use Nevada. And that's because of all the dirty shirts out there, Nevada is the best. It's got the best statute. They've done the best to try to make it work. And so we're going to recite it, but we are not going to take all the effort to meet the requirement to be a full Nevada domestic asset protection trust because that's not the goal of the Bridge Trust. Remember, the Bridge Trust is a foreign asset protection trust. We're only using Nevada as a jurisdiction to meet the two-part test under 7701. So pre-duress, this means before a lawsuit occurs, you do not have any Form 3520, 3528. The trust is treated as a simple domestic grantor trust, just like a revocable living trust. It is literally disregarded for tax purposes. There's no FACTA disclosures. You do not have to set up a foreign account in Switzerland or anywhere else. You do not have to have filing requirements with the IRS of any kind, because remember, it's just a domestic asset. It's just a domestic grantor trust, a simple trust, just like a revocable living trust. The assets can remain right here with your current bank, with your current financial advisor. You don't have to switch to somebody new. You do not have to have a foreign trustee that is in control of the trust. Remember, the control part is got to be with the US person. And who's the US person? Well, how about you? You can be the initial trustee of your own bridge trust. This makes clients very happy because most clients really, really do like to have the control, unless it's critical to give it up. There are times, meaning once post duress, once we really need it, the trust to be working from an asset protection standpoint, that you don't want control. But pre duress, before there's a lawsuit, which in reality is probably forever. I mean, we hope forever. Certainly 95% of the time, we can probably plan on you're not going to be in a lawsuit. You can be the trustee of the trust. And again, the trust stays a tax neutral domestic grantor trust. Very simple. Post arrest, what happens? Well, things change post arrest. Post arrest, trust protector, which you want your attorney serving as your trust protector because you want attorney-client privilege around that. We serve as your trust protector. We can declare an event of duress. This causes a few things to happen. One, that offshore trustee that we said was in a standby role, all of a sudden it's no longer standby. They become a co-trustee with you. And two, they have now the power to remove you as a trustee because you're in the jurisdiction where the event of duress has occurred. And since you're there, you are vulnerable to a court. And so we don't want you in control of the trust any longer. At that point, the offshore trustee can then take whatever steps are appropriate to protect the assets of the trust. This can then include opening up an account offshore in Switzerland or Liechtenstein or Luxembourg or any of the other jurisdictions that are valid. It can include leveraging the assets, stripping the equity. It can include selling the assets. We're going to take whatever steps are appropriate based on the situation, based on the level of threat that the lawsuit is really providing. And we're going to protect the assets as much and as far as we possibly can, which I can tell you is incredibly effective. I mean, incredibly effective. Even if we don't have to go all the way offshore, it's still incredibly effective to have this type of trust in place when someone is attacking you. So let's put it up against our 4-part test. Is it effective? Yes. It's a foreign asset protection trust. If we ever have to use it, it is just as effective as the Cook Islands Trust, because that's actually what it is. 2, control. Yes, you can be in control of the trust right up until the last second where it is apparent that that's not in your interest. 3, cost. It is much more reasonable. It is still an investment on your part, but it is not, $50,000 and $10,000 a year to maintain. And compliance. There's none. As long as we're not triggering the trust, there's no compliance whatsoever. If we have to trigger the trust and go to the full foreign trust, then you'll have the compliance. But remember, at that point, you want it. You're willing to pay for it, because the benefit of the effectiveness is now the most important thing that there is. We want that trust to be effective. So I'm going to put it together with a little bit of a graphic because I think it helps. So the asset management limited partnership, you really want to think about that as your holding company. It's in the center of your structure. That's your core to the plan. It's going to be attached to these little houses down here, which are your LLCs. This is your base layer. They hold your rental property, they hold your airplane, they can hold your boat. And then we have the bridge trust, and then we still use a revocable living trust for your estate plan. So these are your components laid out here. These 5 things. The LLCs are single member, as Brian mentioned, to the extent that we can make them. This eliminates a tax return. It makes your accounting very easy. But since we have multi-member holding company, we still get the protection. The other assets that the holding company can own directly, cash, stocks, bonds, cryptocurrency, anything that's already securitized, anything that's already safe, that's not, doesn't have a key, doesn't go boom, doesn't have risk of it itself. Who controls that asset management limited partnership? You do. You either control it directly as an individual person or through an LLC if we want additional layer of privacy. Who owns that holding company? The bridge trust. And that's the key. The bridge trust actually is the majority owner of that LP. So the bridge trust owns all the assets. So one of 2 things is going to happen. If you die, then everything passes through your revocable living trust. It's very smooth. The estate gets distributed. You maximize your estate tax exemptions. You avoid probate, smoothly pass your assets. It's just exactly the way you'd want to handle it. The other option is we have an event of duress. We have a lawsuit. We have some threat. In that case, the assets can be under 29-333, which Brian stated in the Arizona statute, that the bridge trust can make a unilateral withdrawal from that partnership, demand the assets, then they can be taken fully offshore or put into a safe place, whatever the trustee at that point deems is the most appropriate thing to do. So I just threw out, between Brian and I, we've covered probably 4 hours worth of material in 50 minutes or 44 minutes. So I know we threw a lot out at you. Here's our invitation. If you're at whatever stage you're at, if you are at the beginning stages and you're buying your first property, that's great. If you're at the, you've got $4 million worth of properties and you're not sure if you got it right, either way, we invite you to call us, schedule an appointment, and we'll go over your situation, and we'll and I've got a thing here. I'm going to admit somebody in here. I'll go over your situation and give you a recommendation. And so my information is up there. I don't have, Brian, do you want to give me, let me put your information up there.
Just go Brian at btblegal.com.
Yeah. So contact myself or Brian, and you can schedule a call, and we'll go over everything with you and give you a very clear analysis. Because you're a member of this summit, we don't have a fee for that call. We waive the analysis fee for that call. So that's just our thanks to you, and thanks to you, Mike, for having us on.
Awesome, you guys. Really some great information, and it's so important. Protecting yourself, even when you get started. A lot of the people that are listening are just getting started. And I know you two gentlemen work with serious people with serious assets. However, I think it's safe to say that it's never too soon to think about this stuff. Am I correct in that?
Yeah, absolutely. It's never too soon. I mean, you even if you haven't even bought your first property, you'd rather get this information now, know where you're going, know what you're gonna need, and when to put it in place, than to just do it wrong or wait. And unfortunately, people seem to want to wait, and they feel like they've got to get their assets first. It's really the other way around. Get the information first. Even if it's just one LLC or two LLCs that you're starting with, you want to get them in place with your very first asset.
Yeah, and I think some of the biggest mistakes you're going to make are when you're just starting out. And then that's when most of the largest part of your pie is, I don't know what I don't know. And so you haven't shrunk that part of the pie yet. So you're going to be more vulnerable. The lawsuit's most likely going to wipe you out at that standpoint. So that's when you need to also budget, not just on closing the deal, but what are you going to put it in, and how are you going to protect it? And that just goes in part of your budgeting, just like a normal business. You're creating cash flow business, so treat yourself like a business.
Yeah, I totally agree with you. It's amazing. When I was a banker, there was a gentleman that walked in. He was buying his 10th building, and he wanted a loan from us. And he had everything in his own name because he bought that first property. He had 9 properties in his own name. I was like, oh my God. I said, the first thing you got to do is you got to get in touch with an attorney and put this in a trust, or put it in do something, you know what I mean? Because, he didn't understand, he just didn't understand the liability side of it, which could have, one slip at one property could have really been disastrous.
Yeah, or it's not even just slips. I mean, mold. Like, I've had to deal with like a $40 million, litigation case in Michigan when I was out there, from a big apartment building, and like things like that, like, a big massive mold issue, you have a 2-unit, 4-unit, that can be a $5 million lawsuit. I mean, it's just stuff like that, or just in your own personal life or your business life. The liability is everywhere in your life. It's just a matter of managing it, knowing where the liability is, the risk is at, setting up the system before you need it. Because if you're doing it after you're being sued, I mean, it's going to be really, really expensive, and very thin line of what we even possibly could do for you to protect you at that point. But courts like proactive planning. Insurance is part of, asset protection. Just remember that. It's just a very base level area. And you're talking about, people starting out. Yeah, we work with high end, investors, but your new greenhorn investors, a lot of you watching this, that's where the LLC entry level comes in for you, and insurance. And then just realize you have a long-term game. As you grow, you're going to grow out of that LLC. Then what do you need? I need to manage this better. I need a management company. My goal is to be, a $1 millionaire with $1 million net every year. I then need that asset protection bridge trust. So you got to have your eye on the long game plus the short game, know where you're at and know where you're going, then close the gap.
I totally agree. That most people don't. Most people, we talk about, Mike's book is, exit plan. Most people don't start with the end in mind. And I would venture to say that's probably where people get in trouble.
Yeah. Yeah. They starting with the end in mind is the key to life, right? If you don't know where you're going, any road will do. So you got to know where you're going. And when it comes to the legal part of it, it's just get it right. Get to someone like Brian and I, or somebody, and get it right, and it'll be very easy to manage going forward. You're going to get it wrong, and you're going to have a giant mess, and then the problem occurs. And as Brian said, it's either going to be insanely expensive to try to do it then, and even then you've massively handicapped yourself. The Achilles heel of asset protection is called fraudulent conveyance. Fraudulent conveyance means if you convey an asset with an intent to delay, hinder, or defraud a creditor, that conveyance can be reversed. Well, if you wait till you have a creditor to try to do this, that's the definition of fraudulent conveyance. That's the time that we really can't do it. So if you're listening to this and you don't have a creditor knocking at your door, now is the time to have the conversation.
And I'm going to piggyback off of that because I relate an asset protection system and trust to like wine. You know, you buy a young bottle of wine, you stash it away in your wine cellar, you drink it, open it up 10, 15 years later, it gets better with age. Same thing with your asset protection planning and like the bridge trust is, especially with California, with now like Kilker versus Stillman that opened up that 10-year look back period. Once you hit that 10-year mark and you're past that from the fraudulent conveyance standpoint argument, you now have like literally the strongest asset protection planning system in the world because it's never had to been used. And then once you hit that 10-year mark, you're taking a fraudulent conveyance argument off the table.
And that from you two gentlemen as attorneys, that gives you ammunition where if you have to fight a case, you can do it. Is that correct? Hear that correctly?
Right. Yeah, that's what we want. We want things done so that we can say, hey, fraudulent conveyance is not the issue here. Try again, try something else. If you wait and you do it late, now we're very vulnerable. The entire structure gets vulnerable.
And part of the system of being proactive is, you know, like you're not trying to hide what you have or hide the ball. You know, like these systems like this, when it scales up LLC, AMLP, you know, bridge trust option, you know, anonymity, I think, is just you're falling into a salesman trap. With this type of system, we use this as leverage to make lawsuits go away, because we will just go to the opposing counsel and say, hey, we have an offshore Cook Island foreign, you know, trust. You know, if you don't go away, we're not going to give you anything. We're just going to migrate, you know, drop the compliance, migrate the assets. You will get nothing ever. Right. And any smart business owner, which is what law firms are, will look at this and say, even if I got that $1 million or $5 million judgment, they're non-collectible. If they pursue you any longer, they're going to go bankrupt because they will outspend their profit line.
Right. That's crazy. Can I ask you a question from, and I know you may have answered it. I thought I heard something, but just so we're clarity. So when you set up one of these and your assets are there, and when you go to strip out an asset or sell an asset, are there any disadvantages or advantages to what you're what you've been talking about?
No, it's really just system. Once you have the system set up. So if you're going to buy an asset, you're going to buy it into an LLC. You literally, the title company says, how are you titling the asset? You say in an LLC, they ask for the documentation, the asset goes into the LLC. When you sell it, same thing. So it's really just getting your systems down. Once you have it in place, it's very easy. It's very smooth. The advantages come in the asset protection as well as the tax planning that you can do with the holding company, and the minimizing of your reporting requirements. You don't want 15 LLCs that have 15 tax returns. I can tell you from experience that clients cannot sustain that. Even their accountants who are billing and actually get to charge for these 15 returns are going nuts telling their clients, why do you have 15 tax returns? So there's distinct advantages to having the structure in place. And you don't want all that income coming through on your Schedule E. So right now, if you just have real estate in your own name, it goes to your Schedule E on your 1040. That's not where you want it. Not only is it very apparent exactly what you have, but it's not the place where you can maximize the tax efficiency of the entire structure. And of course, there's no asset protection whatsoever.
Yeah, and I get this. I've actually had two clients just this week that had the same setup issue. And I was talking on another show with a CPA that was like, oh, that was not him, like the guy, but he's done the same mistake. A lot of real estate investors think about taxes first. So they're going to their CPA to say, hey, I want to maximize my tax, revenue and make more money. So where should I put this real estate in? Like right off the bat, they're S Corp. And so they're putting in real estate into an S Corp, which from an asset protection standpoint is really, really bad. And so we prefer the LLC because there's no shares on that. And so I had one client that was, had a Florida property, another state property, another state LLC, all put into S corp, and then they're doing 1031 exchange as a principal, and we can't even exit them out of that property now because of all the 1031 exchange that they were doing. So now, as from a tax standpoint, we are limited in how we can even protect their assets because it's going to cost so much money, from the exiting the S corp, due to the 1031 investment strategy that they were doing. So when you're starting out, my point is for you new investors right here, there's a fine line between tax advantages and maximizing your tax strategies versus asset protection. So you can always make an LLC and elect to be taxed as an S corp, but creating an S corp and putting real estate into that is not the right option that I would recommend going, because S corps have shares. Shares can be seized and frozen.
Yeah, very good point. Listen, when I got started, I was a banker. I bought a 18-unit building. I had no clue. And Doug, to your point, we put everything in single asset LLCs, and it was a nightmare. I was the managing member. I was managing the K1s, and I mean, it was just a nightmare. And the accountant was, he was billing me every quarter. It was going, the billings were going up, and
Not cheap.
I know. And finally, what happened? Finally, we were buying another property, and one of the guys that was going to be a partner was an attorney, and he's like, "What the heck are you doing?" And it's, unfortunately, I think a lot of people just don't think about this stuff until they hear a presentation, like from you two gentlemen or from somebody that's made that mistake, because it's so important. I think it's so important to think about this stuff. Yes, our tax is important, 100%. However, and again, if there's any accountants listening, don't take this the wrong way. My experience is that most attorneys can put on an accountant hat easier than accountants put on an attorney's hat. So whatever that's worth, I'm just saying, what you're talking about, this asset protection thing, is absolutely something to think about.
Yeah. And I have a good question that was posted by the help desk from Facebook live stream, and it goes, has the bridge trust model been tested in a court case?
Yeah. So we've had, like I said, I've done over 3,500 bridge trusts in the last 23 years. But we've had to trigger about 100 of them. So that just tells you how effective it is without triggering. And when we trigger, it's impenetrable. We have never had a forced extraction of any assets from any of bridge trusts that I've ever set up. We've certainly had clients that have voluntarily settled, and that's one of the strategies, is that you put yourself in a position where you're being sued and you have a judgment for $1 million against you and you settle. In fact, the best example I have is I had a doctor client. He signed a bond for his brother-in-law because his brother-in-law wanted to build a project, and he just didn't really understand that he was signing on to be responsible for the entire project. Well, this was in 2007. We all know what happened. And the project went bad. The obligation was $17 million.
Wow.
The client had about $5 million as a doctor in his bridge trust. We settled the case for $125,000. So that's the power. That's what it's about. It's about giving you the leverage. So the answer is yes, the bridge trust has been tested. We do not have any reported cases, meaning we don't have any opinions written by a court around it. I consider that a very good thing. I hope we never have an opinion. Usually opinions are written about things that don't work. So yes, it's been tested. No, I can't point you to any case law around it. And again, I think that's a very positive thing. It's worked without having to be the moniker child for a reported case that they study in law school.
And I'd also remember that the bridge trust is a foreign asset protection trust. So you're using, almost 40 years of supporting case law that goes into the foreign asset protection trust, even from like we were talking about the Anderson case, Grant, and those cases against super creditors, one Anderson Ponzi scheme still upheld, the Grant case, IRS, like 36 million that didn't get paid. They tried to go after that wife 3 times. And, so you have those case laws to support off of.
Interesting. Oh, well, really great, guys. We could talk about this stuff for hours. We're at the top of the hour. Really appreciate your thoughts, and you did share. I see, Brian, you shared how people can get a hold of you. Just really appreciate the insight, and for those of you that are on the VIP program, the Zoom is going to be recorded, so you can go back and listen to this again, because there's a ton of information. Obviously, like I say to most of the speakers, these guys have forgotten things that I haven't even learned yet. So If you're on the Facebook, you can still upgrade, and if you decide to upgrade, you will retroactively get all the recordings. So, guys, thank you so much. I'm glad Michael reached out to you, and if there's anything I can ever do for you, please let us know, and really appreciate everything you've done.
Thanks for having us. Real pleasure.
Thank you so much.
Okay, Doug, Brian, thank you. Thanks a lot.